Hello, I'm Andy Hill, Head of Legal Publishing at Blue Tree Professional, and this is Adrian Laing, co-author of a new book that we're publishing called Contract and Copyright Drafting Skills, and also co-author of a couple of other books that we do, the 8 set of contract clauses and the Media and Business Contracts handbook as well. Hello, Adrian.
Hello.
First question really is, can anyone draft a contract?
Anyone can draft a contract if they've got the sufficient skills and learning to do it. Some people have more of a natural ability than others, but for the most part, you've got to be very specific about what you have to learn in order to draft a contract quickly and confidently.
And what are those points that you have to learn?
Well, you have to understand the basic issues that a contract encapsulates, so that there may be a number of issues within a contract, ranging from indemnity to force majeure. In order to draft it, you've got to understand what those issues are, and you've also got to understand the context of the agreement. So you may not even be starting with the right agreement. You may be starting with an assignment, whereas in fact what the parties really need is a license. So you've got to understand each component of the contract in itself, but you've got to understand the commercial context that agreement is being drafted within.
Okay, that's interesting. And you mentioned that you needed skills as well, certain skills. What would you say those skills are?
The primary skill is to identify what the issues are, what the parties have agreed, and you've got to be able to reflect that in the wording of the contract very clearly. Try to avoid ambiguity, but also you've got to remember that the essence of the contract is to avoid disputes later on. So it's not just as simple as saying these are 6 points that you've agreed. You've got to try to work out what in those circumstances might go wrong in order to draft clauses that express very clearly what happens if something does go wrong, rather than look at a contract and say, well, what happens now? What do we do in these circumstances? Because if you were looking at termination provisions and something's gone wrong, you won't be able to look at a clause that says this clause addresses the situation that we're in now, and it sets out very clearly what we've got to do.
Okay, so how does your new book, Copyright and Contract and Drafting Skills, help with that?
Well, we've taken a number of years to get to the view that it's not just about the detailed wording within the contract. That's addressed in the book, but there are 56 different issues which are addressed. And so we're not just looking at the actual wording of the clauses and how you may amend it, but giving a narrative that explains the circumstances and relevance of those issues within the contract. So if you want to disassemble a contract, or you've got a specific issue that you want to address, it's very helpful to understand the relevance of that issue to the circumstances that you're in.
So you mentioned there were 56 issues.
Yes.
So what kind of issues do you cover? I know you've mentioned determination and force majeure. Some of the other issues.
Well, we go from absence to trademarks. Well, for example, with gross receipts and net receipts, somebody may be struggling to understand the wording of a gross receipts clause, when in fact what they really want to do is to draft a net receipts clause, or they may not even have the right agreement, because it's not about a royalty-based agreement where you're paying out on the basis of a gross receipt or net receipts calculation. It's about a single payment. So you will understand, particularly by the cross-referencing of all the issues in the book, that you can't just look at a contract and be concerned about drafting a net receipt clause unless you understand payments, unless you understand royalties, unless you understand net receipts. And so it's the way in which each of these issues correlate to each other that you get a better understanding as to how you address the contract to start with.
Okay, so, and in your experience, what would you say are the thorniest issues within contract drafting?
The thorniest issues are those which are deceptively simple, because every time I'm looking at a specific clause, there's a number of issues in my mind, one of which, what is the cost impact of this clause? If I'm looking at a contract, I'm thinking, who's paying who, what, and why, and when? And if you get it wrong, there can be very severe consequences. So the biggest mistake that people make when they're looking at a contract is to try to really drill down to what is really going to make a big difference in the way that clause is drafted. Because if you get it wrong on the payments or the royalties or the net receipts, it can affect the whole commercial dynamic of the deal. So the biggest mistake is not understanding that contract is there for a reason, and that's got commercial financial contexts. And if you don't understand the commercial financial context, you can see the wood but not the trees. You get lost in the detail, and you forget that there's a bigger picture.
So do you see, sort of, when you said deceptively simple, they're the ones that people actually fall at? It's really just finding out what the real reason is for the contract.
Yes.
If you don't have that in your mind at all times, that's where you're going to fall down.
Where you're going to fall down is not understanding the consequences of what you're drafting. So you may say, oh, it's a net receipts deal, or it's a sums received deal, but then you say, well, where's the definition of sums received, or where's the definition of net receipts? And in publishing, for example, people can be arguing for years over the detailed wording of a clause, because it's got a very specific cost impact as to the actual royalty that's paid. And so it's deceptively simple, but you're not thinking through, well, is this going to result in a 17.5% royalty under that clause, or a 22% royalty under that clause? So when I say it's deceptively simple, it's the wording can appear simple, but when you take a step back and test run it, and you say, okay, if an ebook is sold, what the royalties am I going to get from that? If a book as published is sold overseas as a book, what's the royalty do I get from that? If the book is translated into another language, what royalty do I get from that? So it may be quite simple to understand what different genres or types of books that you have, but the commercial context is to say, is the contract clear as to what payments are going to be due and when, if the book is sold in that particular format in that territory?
So why, with your experience, why have you decided to write the book with Deborah Fosbrook?
It's a long time coming, this book, and it's a book which I could have done with a few years ago myself. I think it's because contracts can appear to be quite complex. And the reason why they're complex is because you need to understand really what you're doing. And by that I mean you need to, it does help a great deal if you're drafting an assignment contract to understand why you're drafting an assignment contract, because you may not even want an assignment when you think about it. It may be an exclusive license, or it may be a non-exclusive license. And so you can jump into the detail of a contract and think, oh, I know how I can tweak and twiddle with this. But in fact, you've really got no idea what you're doing, because you're actually in the middle of the wrong contract to start with. And so this book is intended to give you an overview, both a wide commercial narrative as to what relevance these clauses have, but then allow you into the detail of what you're doing to say, well, it could be this clause or another type of clause. I mean, just taking gross receipts, I think that there's hundreds of gross receipt clauses that you can choose from, but you've got to understand what you're trying to achieve, and it's that wider understanding that you need in order to make the complex seem quite simple, because actually what you're doing is just twiddling with a clause at the end of the day, if that's what's required. And that's quite a simple job, but you've got to know exactly what you're doing and why. It's like taking the bonnet off a car and it's just a little screw that needs tightening, but you've got to know why you're tightening that screw.
Okay. So in terms of somebody using the book, how would you summarize in sort of, I don't know, maybe 3 bullet points, a summary of how they would find the book useful? The
first way I think the book is useful is for somebody to say, what is it that is worrying me? What is it that I'm struggling with? And it could be that they just don't know whether the particular clause, whether that's an indemnity clause or a payment clause or a royalty provision, is right or wrong. It's just they read it and it just appears okay, but they don't really know if it's okay or not. So what the book does first and foremost is disassemble all these different issues, so that you can, if you're worried about force majeure or an absence or any other type of issue that arises, you then go into the book and look at that issue to give you an overview of what the context is. And then secondly, because there's a lot of variations of those clauses, you can look at the analysis that is in the book and get a very good, quick understanding as to whether the clause that you've got is actually okay or whether it's fundamentally inappropriate. And thirdly, I think it's about having the confidence to both draft a contract and be able to look at a contract that comes your way and say, well, I'm not sure about that clause, and I'm maybe not even sure why I'm unsure, but if you can go to a textbook like this one and it gives you different examples and analyses the issue, you're then in a position to be able to say, the contract may be fundamentally okay, but that particular clause we don't like, but here's a better clause. So you provide a solution to a problem. And that's the whole intention of the book, is to help provide solutions to problems when sometimes you don't even know what the problem is.
That's great. Many thanks, Adrian.
Thank you.